The right to die remains a fiery issue in Australia, with the Northern Territory the only jurisdiction to have legalised euthanasia, briefly, before the law was overturned by the federal parliament. Now the issue is back on the table in Victoria. The state Labor government's Voluntary Assisted Dying Bill 2017 passed Victoria's lower house on October 20, driven by Health Minister Jill Hennessy and Premier Daniel Andrews. Mr. Andrews has called it the safest and most conservative model in the world. But former Prime Minister Paul Keating has intervened, writing a newspaper article warning that once termination of life is authorised, the threshold is crossed. From that point it is much easier to liberalise the conditions governing the law. Invoking a slippery slope argument, Mr. Keating wrote, the experience of overseas jurisdictions suggests the pressures for further liberalisation are irresistible. In places that have legalised assisted dying, has further change really been irresistible? Our MIT ABC fact-check investigates the verdict Mr. Keating's claim doesn't check out. In most jurisdictions where assisted dying has been legalised, little has changed regarding what practices are allowed or who can access assisted dying. There have been some changes, such as in Belgium, where competent minors can now request euthanasia. In the Netherlands, doctors have published guidelines for providing euthanasia to severely disabled newborns. Though these guidelines may help doctors avoid jail, the practice itself remains illegal. However, these countries allow euthanasia. What's proposed for Victoria is predominantly an assisted suicide model. This makes it more similar to the North American jurisdictions, where there has been almost no change. Canada's framework is still new and may yet evolve as it is challenged in the courts. But despite pressure for change in the United States, there has been no further liberalization in any of the 5 states involved. This includes Oregon, where the system has been operating since 1997. Assessing the claim, a Victorian parliamentary committee that investigated end-of-life choices has described 2 types of slippery slope arguments. Both assert that people beyond the initial scope of the assisted dying law will die either through further legislative change, or practice outside of legal safeguards. Mr. Keating's claim deals with the first of these. He writes of the conditions governing the law. Fact check takes further liberalization to mean that a government has taken active steps to expand who gets access to assisted dying or which activities are protected under the law. What is voluntary assisted dying? It's a term used by the Ministerial Advisory Panel on Voluntary Assisted Dying, the expert panel behind Victoria's framework. They argue the term emphasizes individual choice and avoids stigma in a way that voluntary euthanasia and assisted suicide do not. A committee of the UK's House of Lords explains that voluntary euthanasia means ending another person's life at their own request. Assisted suicide means providing someone with the means to end their own life. So although in both cases another person, a doctor, in most countries helps in some way, the distinction rests on who commits the final act that ends the person's life. The expert panel avoided using the term suicide because, the report said, deaths as a result of suicide are avoidable, and every effort should be made to prevent these deaths. Fact check refers to assisted suicide and euthanasia using the umbrella term assisted dying, which is the approach taken by the Victorian Parliamentary Committee. What the Victorian model allows, the Victorian Bill adopts all of the expert panel's recommended safeguards, including strict eligibility requirements. To access assisted dying in Victoria, a person must be an adult, 18 years and over, ordinarily resident in Victoria, and an Australian citizen, a permanent resident of a decision-making capacity in relation to voluntary assisted dying, be diagnosed with an incurable disease, illness or medical condition that is advanced, progressive and will cause death, is expected to cause death within weeks or months, but not longer than 12 months, is causing suffering that cannot be relieved in a manner the person deems tolerable. A person who meets all of the eligibility criteria must make 3 separate requests to access assisted dying. Only after being assessed by 2 independent medical practitioners can they be prescribed a lethal drug. In most cases, the person must then administer it themselves. Where is assisted dying legal? Assisted dying is legal in just a few places around the world. The U.S. state of Oregon was the first to legislate for assisted suicide, in 1997. In some jurisdictions the practice is legally defensible under existing law. In Switzerland, for example, any person can assist another to commit suicide providing their motives are not selfish. Montana's Supreme Court has ruled that a terminally ill patient's consent to physician aid in dying constitutes a statutory defense to a charge of homicide for the assisting doctor. and the Constitutional Court of the Latin American nation of Colombia found in 1997 that euthanasia was not illegal. As the British Medical Journal has reported, it took until 2015 for the Ministry of Health to publish guidelines explaining how euthanasia should be performed. Fact-Check has confined its analysis to jurisdictions that have passed laws with the express purpose of legalizing euthanasia and/or assisted suicide. This includes Canada and Quebec, 5 U.S. states, Oregon, Washington, Vermont, California and Colorado, and the European nations of Belgium, the Netherlands and Luxembourg. Washington, D.C. is excluded because its assisted dying model came into effect only recently, in February 2017, and faces an uncertain future. How Victoria compares. The report by Victoria's expert panel Appendix 3 Parts AC compares the jurisdictions, which, broadly speaking, can be grouped into two models: American based on the Oregon model and European. Each American jurisdiction allows assisted suicide but not euthanasia. Eligibility requirements vary according to the exact wording of the law in each state, but in all cases the person must be at least 18 years old and suffer from a terminal illness that will kill them in under 6 months. Europe is less restrictive. In both Belgium and the Netherlands, a doctor can administer the drug. Euthanasia is not restricted to adults, nor to people with a terminal illness, though they must be experiencing unbearable suffering. The debate in the Victorian Parliament over the issue of voluntary assisted dying went through the night before the bill was passed. Like Canada, Victoria borrows from both models. However, Labour's proposal cuts closer to the US versions. In Victoria, the person must have a terminal illness with a defined life expectancy. And while this period is 6 months longer in Victoria than in the Oregon model states, there is an added requirement that the person must be suffering. Unlike in the US, a doctor may administer the drug on a person's behalf if the person has decision-making capacity in relation to voluntary assisted dying but cannot self-administer or digest the lethal dose of medication. The expert panel argued that this ensures the model is non-discriminatory, and does not exclude people on the grounds of disability. From a medical practitioner's perspective, this may be described as euthanasia, the report said. From the person's perspective, this is also assisted dying. Resisting the pressure to confirm the status of each jurisdiction's framework, Fact-Check has contacted legal experts and local legislatures, professionals and medical authorities. This includes medical associations in California, Oregon, Canada and the Netherlands, and the health departments of Oregon, Washington State, Vermont, Colorado and Canada. None of the American jurisdictions has expanded the activities which are permitted or who can access assisted dying. This includes in Oregon, where the law has existed for more than 2 decades and withstood attempts to amend it, for example, by widening the life expectancy requirement from 6 to 12 months. Eli Stutzman, the lawyer who drafted the original legislation, told Fact-Check that while there have been a few housekeeping changes, these had not further liberalized the model. The Oregon Health Authority said the legislative changes clarified what it meant to be an Oregon resident and introduced a requirement that pharmacies report when prescriptions were filled. Washington State was the second U.S. jurisdiction to pass assisted dying laws. The state's Legislative Information Center told Fact-Check that its Death with Dignity Act remains unchanged despite 4 attempted amendments. Professor Penny Lewis, who heads the Centre of Medical Law and Ethics at King's College London, confirmed to Fact-Check that the only U.S. jurisdiction that has changed is Vermont, but it has become more strict. Indeed, although the Vermont legislature voted in 2015 to amend its original act relating to patient end-of-life choices, this merely made the law permanent and introduced additional reporting requirements. Canada legalized assisted dying relatively recently, after the Supreme Court ruled in 2015 that the prohibition on assisted dying, contained in the Criminal Code, was unconstitutional because it breached the Canadian Charter of Rights and Freedoms. Since the code was amended in 2016, there have been no further changes. However, it could be argued that the change liberalized the rules around assisted dying for the province of Quebec, where voluntary euthanasia but not assisted suicide was legal. With Canada's federal law now permitting assisted suicide, a doctor in Quebec cannot be criminally prosecuted for the practice. The Canadian Medical Association told Fact-Check that the government is now undertaking studies about assisted dying in relation to mature minors, advanced directives and people with a mental illness only. However, these are focused on potential legislative changes, not current practices. Sources: health departments and/or medical associations in Oregon, Washington, Vermont, Colorado, Canada and the Netherlands. Legislatures and/or senators in Washington, Vermont, California and Colorado. Experts in Belgium: Professor Robert van der Stichel, and Quebec Dr. Mona Gupta. Luxembourg is based on advice from Professor Penny Lewis. The Road to Liberalization. Professor Lewis explains that there are circumstances in some jurisdictions where what is permissible under the assisted dying framework could be broadened without changing the legislation. First, where the regime can be challenged using constitutionally entrenched human rights. The Canadian model is an example of this. By requiring that death be reasonably foreseeable, the regime is narrower than the Supreme Court originally required. There are now challenges to the regime brought by new claimants who allege that their rights are infringed by this requirement, Professor Lewis said. Second, in some places legal defenses could be interpreted to permit broader access to assisted dying than the legislation provides. In the Netherlands, for example, doctors can use a defense of necessity when the duty to preserve life and the duty to relieve suffering come into conflict. As Professor Lewis has written elsewhere, if a doctor faced with such a situation chooses to prefer the value that from an objective standpoint is more important, even if in doing so that doctor must do something that in itself is forbidden, the conduct is justifiable. However, she said, neither of these circumstances apply to Oregon model states or to legislation by states in Australia. So what has changed? Though North America remains effectively unchanged, in Europe there has been some liberalization. In 2014, Belgium extended its eligibility criteria to grant some children access to euthanasia. Robert van der Stichel, a medical professor with Belgium's University of Ghent and member of the European Consortium End of Life Care, told Fact Check that this was the only expansion of what Belgium allows. The definition of what a competent child is, that has been enlarged a little bit, so that when children are considered to be competent and autonomous, in exceptional circumstances they can be considered as being adults and given euthanasia. Professor Lewis points out that, unlike adults, competent minors must be terminally ill to access euthanasia in Belgium, and the arrangements have so far been accessed by just one adolescent. In the Netherlands, where assisted dying was always available to dementia patients who have written an advance directive and to mentally competent minors aged 12 to 17, and Professor Jocelyn Downey, an international health law expert who contributed to the Royal Society of Canada's End-of-Life Decision-Making report, said that while some people claim the Netherlands originally excluded non-terminally ill patients from accessing euthanasia, this is not correct. They never had that limit, she said. The Royal Dutch Medical Association KNMG also told Fact Check that there have been no changes to the law since it was introduced. They said that although there is debate in the Netherlands about whether assisted suicide should extend to elderly people who consider the life to be completed, the change requires separate legislation and is not supported by the KNMG. However, there has been some change outside the law. In 2004, doctors from the University of Groningen developed a protocol describing the conditions under which severely disabled newborns could be euthanized. The so-called Groningen Protocol was later adopted as a national guideline by the Dutch Association of Pediatricians. Fact Check considers this protocol to be a liberalization because even though the law did not change, the central government established a committee in 2007 to review decisions made under the protocol. Professor Lewis said the protocol informally codifies and indeed tightens judicial rulings permitting the use of the defense of necessity. As the Canadian Royal Society explains, not only did this practice exist before the 2002 laws, but these rulings did not change the criminal law. Active ending of life without request remains a criminal offence. Professor van der Stichel said there is no legal framework for the practice in Belgium or the Netherlands. It's a protocol of best practice, and if adhered to there is probably, from the judicial system, a tacit allowance. A not-so-slippery slope. Despite these few changes, legal experts contacted by Fact Check agreed there was no evidence of restrictions being increasingly loosened. Cameron Stewart, a professor of health, law and ethics with the Sydney Law School, said there's no evidence at all of a slippery slope in any of the American jurisdictions. He acknowledged the changes to age restrictions in Europe, but also said that in terms of it being a slippery slope, I think the evidence there is really questionable. Professor Downey said, I can't think of a jurisdiction that expanded who can administer the drug and when. The bottom line is that we have not seen evidence of the slippery slope, and there is no good reason to believe that the experience on that front would be any different in Australia. She points to The Supreme Court ruling into reports by both the Royal Society and the Quebec National Assembly, which assess the international evidence and all conclude that the slippery slope arguments are not supported by valid and reliable evidence. This supports the conclusions of the Victorian Parliamentary Committee. The majority report, prepared by members from the Labour, Liberal, Greens and Reason parties, found no evidence of institutional corrosion at the often cited slippery slope. Indeed, the regulatory framework has been unchanged in Oregon, the Netherlands and Switzerland for many years. Dissenting reports were published by two other committee members, Labour and Liberals. Neither suggested the U.S. jurisdictions had liberalized their regimes. Labour's Daniel Mulino wrote that scope creep is occurring in at least some jurisdictions and cited the legislative change in Belgium and those under discussion in Canada. Sources: Australian Parliament, Euthanasia Laws Act 1997 CWTH Daniel Andrews, media released July 25, 2017 Paul Keating, Voluntary Euthanasia is a Threshold Moment October 19, 2017 Victorian Legal Social Affairs Committee, Inquiry into End-of-Life Choices Final Report, June 2016 Ministerial Advisory Panel on Voluntary Assisted Dying, Final Report, July 21, 2017 House of Lords Select Committee on Assisted Dying, First Report, March 3, 2005 Samia Hurst, Polo-Assisted Suicide and Euthanasia in Switzerland, February 1, 2003 Montana Supreme Court, Baxter v. State, December 31, 2009 Owen Dyer, al. For Assisted Dying Law and Practice Around the World, 2015 Oregon Legislative Assembly, House Bill 3337, 2015 Vermont General Assembly, Act No. 27, 2015 Canadian Department of Justice, Supreme Court of Canada ruling, October 12, 2016 Royal Society of Canada, Expert Report on End-of-Life Decision-Making, November 2011 Rory Watson, Belgium expands euthanasia law to children, February 18, 2014 Dutch Government, Regulation 27 Re-Groningen Protocol, March 13, 2007 European Institute of Bioethics, Euthanasia of Newborns in the Groningen Protocol, 2014 Oregon Health Authority, Death with Dignity Act History Royal Dutch Medical Association, Regional Euthanasia Review Committee's Code of Practice, 2015 Tony Sheldon, Dutch Doctors Adopt Guidelines on Mercy Killing of Newborns, July 14, 2005.